Hi friends from around the world, I'm very sorry for you. You have chosen a very difficult case today. Difficult on different issues. Well, one issue I put already outside, which is treated in the limitation of designs. So this is not something, this is Article 21C of the design regulation, which I will not treat here, and it makes it a little bit easier. The other thing is that it is about international jurisdiction, which is one important thing for lawyers from around the world and lawyers from Europe. We want to know where to litigate. Litigate is our blood life beside the filing and the administrative issues. But the blood life and the money is being, so that the interests of the clients, there lies in the defense of their successful action operations on the market. And if it is successful, then litigation comes into play nearly automatically, I would say. So international jurisdiction is a bit complicated. Well, it merits at least 2 videos, and this is the second video. If you want to understand this better here, then you go to the International Jurisdiction 1, where I explain on basis of a simple case what is to decide upon the jurisdiction, international jurisdiction. That one, the International Jurisdiction 1, is on trademarks, and this here is on designs. That doesn't make much difference because trademarks and designs are more or less the same, and the fact that I present here a design case and the first was a trademark case is just to underline that, just that you understand there is no much difference with regard to trademarks and designs. Trademarks, the international jurisdiction is 124. You may remember if you have seen that. And here it is 82 of the design regulation, which is about the international jurisdiction. But here, as it is a complicated case, it go a bit further into other regulations we will see. So let's, that was the setting, so to say. Let's go into it. I explained the case in other videos already. Nintendo is the producer of the video game console and remote controls and accessories, etc. So the Wii is one of these video games, and they have controls which can or accessories with which the body movement you have as a tennis player or golf player, they can be translated onto the screen, right? So that is Nintendo. Nintendo had European designs covered in EU IPO. That is the claimant, so to say. And we have defendant, which is Big Ben. Big Ben France on one hand and Big Ben Germany on the other. Big Ben France is the parent company, Big Ben Germany the branch company of Big Ben France, right? So Big Ben France is the producer of these accessories, and which infringes, that is quite clear, the design of Nintendo, right? That may be something which has to do in the mind of the court, which, well, we will come to it. It is the infringer, right? The Big Ben France is producing these goods and selling it in France and in Belgium. And then we have Big Ben Germany, who is not producing and not stocking these kind of goods, but selling this on the internet in Germany and France. And if a sale takes place, then the Big Ben France is being advised to send the good directly to the consumer. So this is how it is being construed. What does Nintendo do? Well, it sued Big Ben France and Big Ben Germany in one litigation. And here the problem starts. So it was in Germany. Often Germany is very well, so to say, well known for injunction-friendly judgments and for friendly to judge in order to favor the design holder or the intellectual property holder. So they choose Germany. Germany, which is clear with regard to Big Ben Germany, domicile of the defendant. This is 82.1 of the design regulation. So no problem here. And that was practically the first problem we had in the other case. Now, what happens with the other one, with Big Ben France? Well, under the 82 of the design regulations, if you go through, there is no jurisdiction with regard to Big Ben France and Germany. How do we deal with it? So is it possible to have, joined in one litigation, Big Ben Germany and Big Ben France from the two countries, and to make it in Germany where, so to say, Big Ben France has a branch but has nothing, so to say, to do? Well, the community design regulation is a lex specialis, a special law with regard to community design, right? But there is a possibility to make a different, to have recourse to the general rule if the lex specialis is not applicable. And the general rule is here, the regulation which is here on the screen, Article 6.1. Now, Article 6.1 requires that the case, so to say, the case against one and the case against the other, they must be closely related. That is an important issue if they are not closely related, so there would be no possibility in order to get them both in court in Germany. And here the court stated, well, it seems to be that they are closely related because the supply chain comes from France to Germany, and Germany is not stocking anything, so there is intervention from the French company, parent company, so the closely connected, that must be so the case. So this is first thing settled. They can be sued both in Germany. Now, the second case is whether what happened to the accessory claims. What are the accessory claims? Well, accessory claims, the injunction and to stop the infringement is one thing, but then you have all kind of accessory claims such as production of accounts or the damages or the recall and the destruction of the goods, or the publication of the decision, if the decision is positive, and the reimbursement of the fees, etc. These are accessory claims, right? So what about the accessory claims? And again, we have not something being said in the community design regulation. And, it is a bit about the fear of the European Court of Justice to get a dispar judgments in different countries. They want to avoid at all cost this, and often this is a result-minded conclusion they take. Well, they are also competent for the accessory claims because it is based on the same facts and circumstances. Now, the third question is, what about the territoriality? Meaning that is the German court be able to judge about all the infractions, all the infringements which have been committed in different countries? You may remember the 82.1 is the domicile of the defendant, and if we choose the domicile of the defendant, we have the whole community responsibility of judgment, so you can judge on the whole community. You're not confined to one territory, the territory of international jurisdiction, in this case Germany. We are not limited to the territory of Germany. We can rule about infringements of the whole community, whereas in 82.5, where is the place of infringement, if the international jurisdiction is chosen on the basis of the place of infringement, then it would be only the territory of that country, the infringements committed in that country, which would be possible to judge upon. Now, the court, again, they said, well, the accessory claims, the territoriality on the infringement is for the whole European Union. Again, probably on the issue that the thing is a bit, dispar if you go to different countries. Also, and I think that might be, but it is speculation from my side, whether the infringement was quite clear, and well, if we have an infringement, then we want also the holder, the design holder. You want to, perhaps that is human. You want to aid to help the the design holder. Well, but we're coming to the last question. What is about the law applicable to accessory claims? Well, we have the Article 88 of the design regulation, which says that it says nothing about the accessory claims. It is, again, lex specialis, so it is nothing being said on accessory claims with regard to the community design regulation. So again, we have to look into other regulations whether there is something which we need to look at. The Landgericht, the first instance court in Germany, they ruled that accessory claims has to be ruled according to the law where the infringement has been committed, right? The law applicable to the accessory claims. It cannot be done in the community design regulation. It cannot be uniformly done on the basis of community design regulation. No, it must be on the law applicable to the country where the infringement has been done. And this, at the end, was also the conclusion being done by the European Court of Justice, because there is a general rule in that regulation here on the screen in Article 8.2, which says, that must be done in the law applicable to the infringement where it has been taken place. Now, where it has been taken place, that is another issue. What is the action necessary to judge it has been taken place in Germany or it has been taken place in France? And here the court says, rather than taking into account each step of the infringement, there must be an overall assessment of the infringement action to see where is, so to say, the heavy weight of the infraction, of the infringement. And then this would be the applicable law to the infringement. Now, this is not a case which should be overlooked, because the different accessory claims are differently worded, differently, there are differences with regard to the damages and the production of accounts and the reimbursement fees, etc. There may be difference according to national law. So it is an important issue. In sum, it is a complicated case, a very complicated case, which is still crucial, which is still important that you know it. So it is one of the most important cases on international jurisdiction and intellectual property law which we have in Europe. It is a fundamental decision, and it's friendly to the right holders. That is an important issue. It is also a case which can be translated into trademark law. Both are very well connected, and the court says in a certain moment in the judgment that there is, very much connection between one and the other, so that we can probably take out the gist of this, the substance of this judgment, and transmit it into the case law of the trademark. This is now important for your argumentation. So if you want to be successful on the international jurisdiction, you need now, you know now how to put your argument on the table and which line of argument to choose and where to go. So I think it merits, this case merits your attention. And I would say that you would have probably to deal with it at a certain moment. Does that seem interesting to you?